Before going into the topic details, I want to bring your attention to the UPSC coaching programs offered by ClearIAS. ClearIAS offers online and offline courses to help candidates get selected for prestigious government services like IAS, IPS, or IFS. ClearIAS, Prelims cum Mains, PCM course, provides a highly effective study plan, well-organized subject-wise videos, study materials, mock exams, and guidance to cover the entire GS syllabus of UPSC CSE Prelims, Mains, and Interview systematically. As a limited-period offer, there is a 40% discount on our online courses. Enroll now.
Yes, Union Council of Ministers. So what does Article number 74 says? Article number 74 says that there shall be a Council of Ministers headed by the Prime Minister to aid and advise the President of India. So this is what the script of Article number 74 says. There shall be a Council of Ministers headed by the Prime Minister to aid and advise the President of India. So which is very clear that the President of India will have to perform the functions in accordance with the aid and advice of the Council of Ministers headed by the Prime Minister. But the problem was that you may say from 1950 onwards, there was some kind of friction between Jawaharlal Nehru and Dr. Rajendra Prasad. Dr. Rajendra Prasad said that it is not binding on me. That means whatever advice you give me, it is not written in the constitution that it is binding on me. This was the version of Dr. Rajendra Prasad. Dr. Rajendra Prasad said that President is the head of the state. Whatever advice you give to me is not binding on me. You can advise me, but it was not binding. But Pandit Nehru said that is not exactly the case. We are the elected members. We are the popular leaders. We are the decision makers for the people of India. Whatever we decide, you will have to give the signature. So there was conflict regarding the role and the position of the President as well as the Council of Ministers. By the 42nd Constitutional Amendment Act of 1976, what would have Indira Gandhi done? Indira Gandhi said that whatever aid and advice the Prime Minister and the Council of Ministers give to the President of India, just accept it. It is binding on the President of India. Whatever aid and advice we give to you, it is binding on you. So that was totally undemocratic, you may say, isn't it? There is no provision for the checks and balance. If it is binding on the President of India and if it cannot be inquired by any court, means there is no possibility of checks and balance. And that was in fact becoming a reason for a criticism from different parts of the country. Now, as you know, after the emergency, Indira Gandhi faced the election. She was lost miserably. Now, by the 44th Constitutional Amendment Act of 1978, Morarji Desai has relaxed this provision. Morarji Desai said that the aid and advice provided by the Council of Ministers headed by the Prime Minister to the President of India is binding, but the President can return it back for once. If it is again given to the President of India, there is no option. You will have to give the signature, or you will have to bind, or you are bound by the decision of the Council of Ministers. So there can be a question that the 42nd and 44th Constitutional Amendment Act has made the aid and advice of the Council of Ministers headed by the Prime Minister binding on the President of India. Right or wrong? Okay? I'll write the statement here. the 44th and the 42nd Constitutional Amendment Act made the aid and advice of the Council of Ministers binding on the President of India. Is the statement right or wrong? What do you think? Is it right or wrong? It is well evident from the board, from the screen itself, it is evident that it is binding on the President of India, isn't it? 44th as well as 42nd did not deviate away from the binding factor. But 44th has just relaxed the provision. That's it. But still it is binding. So one suspension can be used. That's it. But once if the Council of Ministers again reiterate the same decision, that needs to be compulsorily followed by the President of India. Fine. So this is what you need to understand regarding article number 74, a very important one, very important article which you need to understand, article number 74 of the Indian Constitution, which has got this meaning that both the 44th and the 42nd Constitutional Amendment Act has made the decision of the Prime Minister and the Council of Ministers binding on the President of India. Article number 75 says that the Prime Minister shall be appointed by the President of India. By the President of India. The Council of Ministers will be appointed by the President of India on the aid and advice of the Prime Minister. Fine. So article number 75 says about other provisions of the Council of Ministers, which says that Prime Minister will be appointed by the President of India, but other ministers will be appointed by the President of India as per the aid and advice of the Prime Minister. And that is mentioned in article number 75 of the Indian Constitution. Article number 75 also says that the maximum strength of the Council of Ministers should not exceed 15% of the total strength of Lok Sabha. And this was originally not there. It was inserted by the 91st Constitutional Amendment Act of 2003. Fine. Which means the Council of Ministers' strength should not go beyond 15% of the total strength of Lok Sabha. Say for example, the problem was that the Council of Ministers or the leaders, those who wanted to be part of the Council of Ministers, used to get included in the Council of Ministers all the time if there is no limitation on the members of the Council of Ministers. And that is the reason why by the 91st Constitutional Amendment Act, it was the time of Atal Bihari Vajpayee. So he said that there needs to be a limit on the size of the Council of Ministers, and that will be fixed at maximum 15% of the total strength of Lok Sabha. It should not go beyond that. Fine. At the same time, the same Constitutional Amendment Act of 2003 also said a person disqualified under defection is also disqualified to be a minister. If a member of the parliament, as per the anti-defection law, is disqualified, means he is not fit to be a minister also. So you can just imagine the situation that there was a 6-month exception period, isn't it? Without being the member of the parliament, a person can become a minister. So that loophole was closed. A person, if disqualified from the parliament due to the ground of defection, will not be allowed to become a minister also. So that is again a disqualification to be a minister also. Disqualification Yeah, that depends on usually the disqualification due to defection is almost 6 years as per the anti-defection law. So that person, suppose if disqualified due to any other act, say for example, it's not about disqualification due to defection, suppose there are other disqualifications also as per the Representation of the People's Act, dowry, then untouchability, criminal offences. So that person will be sent to jail on the conviction or the decision of the court. So that particular period in which he remains in jail plus 6 more years, he will be disqualified to contest from elections. Fine. So that is how even the other disqualifications also work. Okay. Now this is what you need to understand regarding article number 74, the first 3 provisions. Now the article number 74 also speaks about collective responsibility. So we have spoke about collective responsibility in the last class, isn't it? Or I think in the first class we have, when we dealt with the parliamentary form of government, I have spoke about collective responsibility. What do you mean by collective responsibility? The Council of Ministers are collectively responsible to Lok Sabha, which means in case if there is no majority in Lok Sabha, the entire Council of Ministers will collapse. They will swim and sink together, isn't it? There is no difference between a minister who is a member of Lok Sabha and Rajya Sabha. They will entirely collapse. This is what do you mean by collective responsibility, and that is also mentioned in article number 75 of the Indian Constitution. A person can become a minister without necessarily being a member of parliament is also mentioned in article number 75 of the Indian Constitution. The salary of the Council of Ministers will be determined by the parliament, even that also mentioned in article number 75 of the Indian Constitution. The oath of affirmation will be addressed by the President of India, that also mentioned as per article number 75 of the Indian Constitution, which means other provisions in relation to the Council of Ministers is mentioned in article number 75 of the Indian Constitution. The title itself says that article number 75 provides other provisions in relation to the Council of Ministers. Clear? Fine. Now, what do you mean by individual responsibility? There are 3 types of responsibility, you may say. One is collective responsibility, which we have understood. Now, what do you mean by individual responsibility now? The ministers have individual responsibility also. And what do you mean by individual responsibility? Responsibility to that particular ministry. See, individual responsibility basically means, see, the people have ultimately given the power to the Prime Minister or the Chief Minister, which means in case of the Prime Minister ask for a resignation, fine. If the Prime Minister asks for a resignation from any ministers in his Council of Ministers, that particular minister will have to give the resignation. Otherwise, the Prime Minister can ask the President of India to remove this minister from his team. Fine. That is what do you mean by individual responsibility. And what do you mean by legal responsibility? Our ministers does not have legal responsibility. Why do we say that our ministers does not have legal responsibility? What is the reason? Okay? Not responsible? No, legal responsibility means in Britain there is a practice of the ministers having legal responsibility, which means in Britain, if the British Parliament enacts a bill It is sent to the British Crown, and if the British Crown gives the signature, then under the signature there needs to be a countersign by the concerned minister also, which means ultimate responsibility lies with this minister. If there is any wrongful provision in that particular law, the responsibility will not come over the crown. That will be hauled, or that will be on the shoulders of the minister. So counter-signing means the final authority signing will be having the responsibility, isn't it? So in Britain there is a quote that the crown will not perform wrong. They keep the crown as a sacred position. We does not want the crown to be committing wrong. And we have certain immunities for the President of India and the Governor, you know. Isn't it? From the criminal proceedings, from the civil proceedings, 2 months prior notice is required. So we have certain immunities for the President and the Governor. The same kind of immunity you can see in the British Crown also. He is not supposed, or he will not be considered as performing wrong. Fine? And that is what do you mean by legal responsibility. But in India, the ministers does not have the legal responsibility. The ministers are not supposed to countersign the bill that is signed by the President of India. Fine? Now, regarding the composition of the Council of Ministers.
Okay. Yes.
So you know that the Council of Ministers, it's a big body. In Council of Ministers there is a cabinet, and this cabinet is the nucleus of power.
Yes.
Why? Because the most important portfolios will be handled by those ministers who have the cabinet rank. So all decisions will be taken by the cabinet ministers in the name of the decisions of the Council of Ministers. The decision will go out in the name of the Council of Ministers, but it will be actually taken by the cabinet ministers. And beyond the cabinet ministers, you have the Minister of State. With independent charge. And finally, you have just the Minister of State. And say, for example, Suresh Gopi, George Kurian, they are just Minister of State. They are just trainees. Minister of State. They will be just assisting the cabinet ministers. They does not have independent responsibility. They will be assisting the functions, the office of the cabinet minister. But Minister of State with independent charge will be having a responsibility independently, but not cabinet rank. So for the cabinet meeting, usually the cabinet ministers will only participate. In certain special cases, these ministers will also be invited. The Minister of State with independent charge will also be invited. That's it. The Minister of State usually does not participate in the cabinet meeting. Fine. So that is what you need to understand regarding the composition of the Council of Ministers.